Good afternoon, everybody. I'm Brian Tully, and thank you for joining our webinar entitled Estate Planning. What exactly is it, and why would a young family need it? I'm grateful you're here with us, and like always, we'll get started in just a few minutes. Let people log on and register. We'll see you back in a minute. All right, let's get going here. I'm going to put the camera back on. All right, so where's our guest? Tony.
How we
There we
doing, Brad?
go. There he is. Very good. Again, thank you everybody for joining us. I'm grateful that you're here to hear about estate planning and how it can benefit yourself and, of course, younger families. So we could be talking about our older clients and them referring to their children, or our younger clients that we've been working with more and more. Um, Today we're joined, and I'm grateful for this as well, we're joined by Tony Farina. Tony gratefully joined us as a partner at Tully Law Group within the last couple of months in 2024. He has spent years alone with his own estate planning practice, concentrating on serving families with minor children as well as high net worth individuals. His focus is helping clients plan for the rest of their lives, protect tangible and intangible assets, and creating meaningful legacies for generations to remember. Tony is both a husband and a father, and because of that, he understands estate planning from both sides of the table. His approach to planning is centered on educating clients first by translating complex legal topics into easy to understand real life examples that will empower clients to make planning decisions so they can protect their families and their finances. Outside of office hours, Tony is probably playing bogey golf. Well, we'll see about that.
Yes.
Watching baseball, spending time with his wonderful family, or planning his next family vacation. So again, we're grateful to have Tony as a partner here at Tully Law Group. He's been nothing but an asset to us thus far, and we expect that to continue for years and years to come. Some of you watching have already met with him. And you can see his style and his way of explaining more complex topics in a rather, again, relative and humanly way, not some academic attorney way. So welcome, Tony.
Thanks,
Thank you
Brian.
for joining us. You're welcome. You're welcome. So to kind of get into the topic and what you bring to us as a law firm is this idea of estate planning, not only for the younger, but more of but also the higher net worth. Today, we're going to focus on the younger folks. Um, and with my background as an elder law attorney, we of course did planning for younger folks, but we didn't really focus on it. And because it has its own intricacies, and we're going to get into some of that today. So we'll certainly have a dialogue. Our viewers will be able to enjoy what we're going to talk about and learn. But let's start with this rather basic question, Tony. So from your perspective, what is estate planning?
So, estate planning to me is this idea that we are planning for the rest of our lives, but also for what happens after we pass away, right? And I think that's the common myth is estate planning is just about planning for your death, and that couldn't be farther from the truth. The truth is, everybody needs to get organized. We could all do a better job of getting our legal and financial lives organized, and I think that's what estate planning is really all about. It's making sure that things are really put together. God forbid something does happen to us, so it's as easy as possible for our loved ones.
Good. Well said. Is estate planning for everybody, younger folks, older folks? To
That
talk about that, who's it for?
Definitely for everybody. And that is the other myth, right? Everybody always thinks we're just needing to plan for this when we're aging and getting a bit older, dealing with health concerns. But imagine the weight of a young parent if something happens to one or both parents while the children are minors.
Mm,
We need to have that plan in place because unfortunately, if we don't, New York State has a plan for us, and most of the times people don't love New York State's plan. So whether you're just getting started in life, you have a life event, new baby, new marriage, even people who don't have kids need incapacity planning to some degree. And so estate planning really is for everybody, no matter their age, their status, their wealth, their family dynamics. It really covers everything.
true. The but there are different factors we can look at. So sitting with a 35-year-old couple with young children versus an 85-year-old couple, right? So there are different factors that go into planning and recommendations. So age is one of those factors. What are some other factors that can help us form our recommendations?
Yeah, I think we talk about this all the time, Brian, whether we're at lunch or, just in meetings inside, but there's this kind of continuum of life and different stages that we go through or life events. We get married, we have kids, we start a business, we get older, we have grandkids, we start to worry about health issues ourselves. And so every stage of life is a new thing to consider when we talk about planning. Our
Mm,
assets grow, the law changes, and we don't know what the future holds. So, at each stage of your life, there's always going to be a new consideration. When you're 35 and you have two little kids, most people will think, oh, I just want to get my will in place. I just want to have that foundation set. And then as we get older, we start talking about asset protection and making sure that we are considering the possibilities for qualifications of Medicaid.
mm,
And the list goes on and on. It doesn't matter what stage of life you're in. What
mhm.
our job is to try to illuminate the spotlight on those issues so people can figure out exactly what they want to plan for and what they need to plan for.
Great, good point. So focusing today on younger families, and again, you also bring a higher net worth perspective to our practice. But what are some of the major concerns that younger families need to keep an eye on, and why should they plan? And then we can kind of flush that out as we go forward.
Yeah, so for younger families, especially those with minor children, I think the first thing that comes to mind is, our kids, right? All of us, if we have kids, we would do anything for our kids. I see parents walking down the street with strollers that cost $1,500 and they have all these bells and whistles, and we really would do anything for our kids. And so the guardianship aspect is probably the number one factor that we look at for young families. And what does that mean? And
Mm,
and when
right,
I say guardianship, there's this traditional sense of yes, we need to name guardians in our will, because that is the legal document that will get a long-term guardian appointed if something happens to us.
right.
The other point of that is what about the short-term plan?
Mm,
How will these guardians, if they're taking care of our kids in a short or a long-term basis, get that legal authority if first responders or somebody is there?
right.
What about medical decisions and where they go to the doctor, what their allergies are, medications, these things that we know as parents, but if grandma and grandpa come over, they might know some of that information, but they might need some of that information. And so we try to incorporate those types of things into all the planning.
Mm,
Beyond that, the wisdom, the values, the family values, the insights, the intangible things that are unfortunately so often lost in this documents only kind of traditional way where yes, we get your will in place, but
right.
that's just the outcome. What we really want to do is guide these parents to pass along the intangibles just as much as they're passing along the tangible things, because ultimately that's what the kids will remember most.
Absolutely.
Um, so as far as guardianship, that's the biggest thing that we want to focus on when we're talking with young families.
Yeah.
And then there's the asset side of it. And of course, we want to protect the assets. And of course, we will. We do everything we can to educate people about probate and what does probate mean. I always explain probate as this necessary thing if you don't plan to avoid it.
Hmm.
Truth is, if you don't have a plan, New York State has to figure out what happens to all of your stuff if you haven't planned for it. And so, while a will is enough to at least name long-term guardians, it's not enough to avoid probate. And so we really have to spend a lot of time with these young families to figure out what is important to you. Is keeping the continuity of assets for your minor children important to you in avoiding probate? And if so, what does that process look like? And so we really have to start from the beginning,
Hmm.
and touch those two critical things, right? Is taking care of our kids and protecting our kids,
Hmm.
passing down those intangible assets in addition to passing down the tangible wealth as well.
Yeah, great points. The um, been doing this for over 25, 26 years, and I can clearly say one of the most difficult issues for younger clients is determining who, in fact, would be that guardian.
Right.
And the reality of sitting with a husband and wife and a couple, and they have not yet decided that. I can almost guarantee you it's not getting decided that night.
Right. There's usually a bottle of wine or something that has to get into pass that out. So,
Yeah, yeah.
uh,
Somebody, yeah. Chances are somebody's getting kicked under the table that first night for sure. Because the husband might say, "Oh, well, my brother will take care of the kids," and then the wife will go, "Your brother can't even keep a plant alive. What is he going to do with our kids?" Right? So
right.
it's certainly a discussion, and there's knowledge and there's input from us as far as how it can work and not work. And so guardianship, absolutely huge. And we could talk about it, the other issue as we move forward, the idea of legacy. And then finally, another very valid point you just mentioned, the third one, which is the inheritance passing down to the kids, right? We certainly don't want kids inheriting at 21 years of age. We don't want kids obviously inheriting younger. So we have to be careful and mindful of how we're structuring that inheritance. I mean, if you'd like to get into it a little bit now, that'll be good.
Yeah, I can just imagine myself at 21, God forbid something happened to my parents, receiving a little bit of money, thinking I
Right.
was set for life.
Yeah,
And
that's
definitely not the case, right? So many
it.
things change from an economic landscape,
Mhm.
political landscape, you name it. But we definitely don't want our 18 to 21 to 25-year olds, even young adults today in
Right.
their late 20s and early 30s,
Hmm.
may not be prepared to inherit what we have built over our lifetime. So whether you're a young family just getting started with life insurance and maybe you have $500,000 or whatever your life insurance policy is, you probably don't want that going to your youngster when they turn 18 or 21.
Right.
And if you're of retirement age or a little bit older, you may not be ready for your late 20s to early 30s, son or daughter to inherit, whatever wealth you've built over the course of your life.
Right.
And so we have to be very thoughtful about the way we structure inheritances because we don't want that financial immaturity to result in a loss or a quick loss of what we've built over our lifetimes.
Sure, sure. And there's also external factors. There's accidents, there's health issues, there's divorces, and again, that's an older group of clients. But the planning that we undertake for younger families, we want to incorporate that as the family ages. So
Right. And there's definitely a few ways we can do that. I think the most familiar thing that people are used to is this idea that I want to give an outright inheritance
mhm,
to my children.
right,
And I'd like to give them half of my assets when they turn 30 and then maybe give them the remaining half at 35. Or
yeah,
you can imagine any different combination that people will come up with.
right,
But there is an alternative solution. And when I hear people say, I want my kids to have access to this money, I want them to be able to have control over it. I always try to ask, is there a concern about any protection? And whether that be a lawsuit, creditor, bankruptcy, or the ever-present mindset in our society today, the possibility of a divorce. And when we look at these assets, the challenge is, well, if I've left my son or daughter a bulk of money, I don't like the idea that they could get divorced and maybe lose half of that to their undeserving spouse. And we need to structure our plans to protect that. One of the things we talk about all the time, Brian, is that lifetime asset protection trust, and how do we structure that so that our kids can receive this money in a responsible way, still
Mhm.
have some control over it,
That's right.
but create this protection, this box, if you will. We're handing this inheritance to them in this box where the only person who can get inside is the people you intend to, your kids.
Mhm.
And
Mhm.
make sure that any of those outsiders, those creditors or potential divorcing spouses or issues that may arise from things that we can, not necessarily foresee are protected. And that's exactly what we counsel on, especially for our retiring clients and aging clients who are looking to leave their wealth in a responsible way.
Yeah. Again, these 3 points of guardianship and legacy for family, and protecting the inheritance for children. The um, if there is no will or trust establishing this, right? So if there's no, and this happens too, because as much as we'd want all young families and adults to hear what we're saying and heed our advice, a lot won't hear it and a lot won't understand it, or rather won't implement it, understand the need for it. So if there is no named guardian, right, we're looking at court intervention. Granted, the court will be involved to appoint the long-term guardian, but if there is no guardian named in a parent's will, you're just setting yourself up for a battle. You're going to have two sides of the family arguing about who should actually be the guardian that's involved, right? I mean, that's a huge risk if they don't do this.
Right. So, you asked what is estate planning, I guess, in the beginning of this conversation. And what estate planning is it's keeping your family and finances out of court and conflict. And if you don't have a plan to do that, guess where your family and your finances are going? They're
Right.
going into court and conflict because New York State has to have that plan in place for those who do not plan themselves.
Right.
And when it comes to guardianship, right? I might think my parents are best suited to take my kids, God forbid something happens to me and my wife, and my wife might think that her parents are best suited. And you better believe that's an opportunity for conflict that can be avoided with thoughtful
Right.
planning.
Sure.
Uh, and that's what we really try to achieve is to help guide those
Mm.
clients,
Yeah.
who's involved in the kids' lives and who would love them, who would be there to take care of them, not necessarily financially, because it's our job as parents to make sure that we're providing financially for our kids,
Hmm.
even if something happens to us. And if we don't structure that the right way, I fear that more families are ending up in that court experience and that conflict experience than have to be in what is already a traumatic time.
At all ages. We're seeing that at all ages, unfortunately. Now, that second issue you spoke about is the idea of legacy. And this is a real factor. And I know people who have lost spouses and they're no longer obviously there then to help raise the children. But not only that, they're no longer there. The values that a parent can instill in a child, the memories they can help build, the family legacy of generations and traditions, if that's not accounted for and that's not intentionally a part of a legacy and inheritance, then if God forbid there is that tragedy with parents, that's gone, that's lost. So and I know that when you are working with younger families, you're putting together and recommending that these parents put together a form of legacy so that these children will know who you are regardless of what might happen down the road.
Right. So, and that all comes from personal experiences too. We've all dealt with loss. We've all dealt with maybe not to some degree as others, but we've all lost loved ones and realizing that some of those stories do fade.
Mm,
And when we talk about our kids, especially as young families, there's two real things. The first part is we want to make sure that our kids are raised the way we want by the people we want, no matter what. Right. And we want to give some guidelines or what I call a playbook to those guardians that they can consult things on. For
mm,
example, discipline or where they should go to school, what religion they should follow, what holidays they should celebrate, how should financial literacy be taught. These are all things that can and should be documented as part of a plan for a young family and
mm,
something that we help undertake, as you know, Brian. But
mm,
the other piece of this is transferring the macro factors of our family's values. the stories and the wisdom that our parents have instilled in us and that we want to instill in our children if something happens to us and we're no longer there. And we only have to look at our own personal families to see opportunities where, man, I would have loved for my grandfather to be able to tell these stories to my own son, who, shares the same name as him, but my grandfather passed away before my son was born. And we don't have that opportunity now to have that story told other than we tell those stories ourselves. And what a powerful experience it is to have that in writing.
Mhm.
Uh, and what we do as part of our plans as a value add to help tell those stories and instill that future legacy for generations to enjoy.
100%, 100%. You're right on the money, and I'm grateful that we've been able to expand into that area and help families with this. Um, the idea of a will, you've mentioned the last will and testament. If there's one call we get the most, it's somebody calling to say, "Hey, I need a will."
Sure.
You touched upon probate a little bit earlier, but a will, we'll just say it flat out. A will is not enough. A will is a part of a plan, and honestly, it's something you don't even really want to rely on for the financial asset. So talk a little bit about if somebody just has a will, or what else needs to get layered on top of a will when it comes to planning.
Yeah, so I think we can start with this idea that everybody needs comprehensive planning.
Mm,
Question is, what is comprehensive planning? And unfortunately, the media or the mass marketers, or however you want to look at it, you can look at Susie Orman, you can look at advisors and legal Zooms. It's just get your will, just get this and just get that, and you'll be fine. But what that really does is provide this false sense of security, right? You essentially have this document or this set of documents that, one, you don't even know if it was executed properly, and two, you don't know if it is actually what you wanted. If you wanted comprehensive planning, how do you know that if you were just purchasing something off the shelf?
mm,
As far as the documents go, yes, as a foundation, we want to make sure we have those core four documents as a bare minimum, which is the
mm,
last will and testament, your
right.
power of attorney, someone who can make the financial and legal decisions for you.
Hmm.
If you cannot make them yourself, and let it be known that just downloading that form online is not going to cut it. There's a significant amount of modifications that have
Hmm.
to go into that document in order
Right.
for it to work when you need it to
That's right.
work. And then your healthcare proxy and living will, dealing with healthcare decisions if you cannot make them yourself, end of life
Mhm.
decisions if you're in that permanent, irreversible, or terminal condition.
Yeah.
Want those artificial machines to be withdrawn if you're at that stage. That's kind of the core four, but contrary to popular belief, that's not enough to avoid probate, right?
No.
It's just not. You have to layer in additional strategies if you want to reduce, costs of probate, you want to avoid probate, you want to have your family avoid that
Mhm.
conflict or that process, and you need a trust in order to do that. There's just no two ways about it. You have to look at trust planning and see if that's right for your situation if you want your family and finances to avoid court.
Right, which is my exact next point, the idea of a trust. So you have a great way of explaining what a trust is, and there are different types of trusts. There are revocable trusts and there are irrevocable trusts. So conceptually talk about that, but for younger folks, we're generally talking about revocable trusts.
Right. Right. And so no matter the type of trust, I'm going to take a stab. I think I know what you're alluding to in terms of my illustrations that go with
Yes.
clients, but I try to explain to clients how a trust works because there's a lot of information out there. And
Mhm.
what I describe to people is think of a trust as this little red wagon, right? It's a vehicle. That's really what it is. It's a vehicle to get your assets to the next generation. And if you imagine yourself right now in this moment, if you don't have a trust set up, you're carrying everything close to your chest, right? You've got your house, you've got your brokerage accounts, your bank accounts,
Okay.
and you're carrying those items with you as you walk down the street. But if you trip and if you fall, you're
Mm-hmm.
going to spill those assets all over the street.
Mm.
Fall is meant to symbolize your death. And if you're gone, someone has to clean up that mess. And that mess is New York State's probate system. The judge is going to marshal up all those assets from the street, gather them up, figure out who you owe money to. The courts have to get paid, the lawyers have to get paid, and then the money goes and gets transferred to the next generation.
Months later. Yes.
Right, months later. And it takes a lot of time to do that and a lot of effort. So if we want to avoid that when we're walking down the street, instead, let's put our assets into this little red wagon, this trust. And we've got our house in the wagon, we've got our brokerage accounts in there, we've got our bank accounts in there. Not the retirement accounts, but that's a subject for another another webinar. But as we're walking down the street holding our assets, if we trip and if we fall, what's going to happen, Brian, is those assets stay packed neatly in the wagon. The only thing that happens is the handle drops, right? But all those assets stay organized right there. And the only thing that has to happen is someone needs to pick up the handle and bring those assets where they're supposed to go. That somebody is your successor trustee. It's somebody that you name inside of that contract, inside of that trust agreement that we create for so many clients, so that a judge never has to facilitate any of those transfers. It's already been pre-negotiated inside of that trust agreement. And that's what keeps the continuity. That's what eliminates all the time. That's what eliminates the significant costs when we pass away. It opens the door for tax planning opportunities. It opens the door for long-term care planning opportunities. And it opens the door for protecting those assets when we leave them to our children in those lifetime asset protection trusts. So it really is like a Swiss Army knife. It covers so many different things that are critical to many different families, all accomplishing that goal of avoiding court, avoiding conflict, and protecting our assets long-term.
Absolutely. And I do love the analogy. And it makes sense. The first time I heard it a while ago, I was like, But now the more you say it, it makes complete sense. It is that vehicle that keeps everything bundled together, and the next person just simply picks up the handle and keeps moving. So we because of the probate complexities and delays, and not even to mention in this world of probate, and I'll just kind of give our primary reasons for avoiding the court systems and reasons why a revocable trust is better, is I mentioned delays. So you're talking in Suffolk County, you're talking 6 to 9 months for a probate proceeding. Nassau County is going to be a little bit less. So that's one reason, this significant delay. Secondly, there's court fees that you mentioned, there's lawyer fees. So it's more expensive to go the probate will route than the trust route. And finally, you're looking at the idea that everything filed in that courthouse is public property. So your probate petition, if we have a person deceased and there are assets passing through their will, there's a probate petition filed with the court listing the children, listing their addresses, what they're inheriting. If they're minors, they're in another section. If they're disabled, they're in another section. So people viewing this, outsiders, are going to know everything about your family. And in this day and age, with identity theft and fraud and all those horrific concerns, we don't want our clients going through that. And as you very eloquently said earlier, we want to avoid courts and we want to avoid conflict. And probate just opens the door, obviously for court, but also opens the door for conflict. So making sure families of all ages have a probate avoidance component to their plan, either revocable trust or irrevocable trust, is certainly what we're going to recommend for our clients because it's the best thing for your family. There's a lot of attorneys out there that will unfortunately just prepare a will. It's a 3-4 page document because that's what the client asked for.
Right.
When clients come in and say to us, we want a will, we know in all of our decades of experience that there's more that's needed, and it's not a 4-page will. There are certain risks out there that we have to address. The idea of long-term care, the idea of premature death, the idea of disabled beneficiaries, the idea of estate taxation. There's so many concerns and issues and risks that have to be addressed in a plan so that you can sleep well at night, so that there can be that peace of mind, so that when you know you have the plan done, it's done. Okay? Yes, there could be opportunities for updating it later on, but at least you've got the right plan for the time being and for the future. For sure.
And so one point there, Brian, just to kind of build on that a little bit. So many families, and when I started my practice, I had a few people look at me kind of confused when I said I'm going to serve young families and I'm going to look at doing revocable living trusts for them. And they said, no one's going to sign up for those plans. Trusts are for the wealthy. Trusts are for people
Yeah.
planning for Medicaid. And what I would argue is, yes, they are important for all of those people, but they are arguably just as important or more important for families of modest means,
Yeah.
people who don't have as much as the wealthiest of the world, or the 8, 10, 12 plus $1 million families, and
Yeah.
for young families who need to keep
That's
things
right.
private
That's right.
and keep
That's right.
things going for their kids, their minors, if something happens to them. And we built a lot of traction, and our reputation was built exclusively on that, really looking to do that.
Yeah.
And that revocable living trust really does wonders for young families. And that connotation of, oh, trusts are only for the wealthy, it really couldn't be further from the truth. And it's so important to learn about every option that you have
Yep.
when planning, so you can make the best decision for your own
Sure.
family. That's really what
100%.
it comes down to.
And as you're talking, it just this, I'm just thinking of families that we've had to help through the years that didn't avoid probate with minor children. Um, Believe it or not, not only is probate the a complicated process in and of itself, but the court, when you have a minor child, even with a biological parent still alive, they're going to appoint their own guardian ad litem to oversee what's happening with that child's inheritance. So the costs are astronomical, the stress is ridiculous, the time frame, because now you have another attorney interjecting into the process. We can go on and on as to why young families should avoid the court system. So I'm grateful that we got into that for a bit. So we're going to start to wrap up. And for our viewers, we're certainly going to ask if there's questions. I know we've had a few more people jump on since we started, so we'll certainly open up to questions in a moment. But Tony, what would you like to share to kind of to wrap it up, to summarize what we've been covering as far as younger families and estate planning before we get to the questions?
Yeah, I just would first say thank you, Brian. The opportunity has been great to join the practice. I've really enjoyed working with all the people here at the firm, and then the clients. But if you have loved ones, or you need your own planning, or it's been 5+ years since you've had your plan reviewed,
Mm-hmm.
we don't know what's changed in your life. We don't know what's changed in your assets, but we do know what's changed in the law. And we know that those three factors have
Mm-hmm.
significant impact on what your planning needs are. And so we would love the opportunity to work with you, your family members, to conduct those reviews and give the education so that you're making the best decision for your own family. Ultimately, we want that long-term relationship, and we've got the process to try to make sure that happens.
Mm-hmm.
So if we can reach out, or if you have questions for me, you can reach out to me anytime, and find my information on the website.
That's right. Which is tullyelderlaw.com. Again, tullyelderlaw.com. So getting into questions, and thank you, Tony, before I jump into that, you've rounded us off very well as far as a law practice, and you bring a level of expertise and a level of support and service that is second to none. So we're fortunate to have you. All right, Mr. Anonymous Attendee. Who controls a trust, and do we lose control of our assets when we set up a trust? So, who controls it, and do we lose control?
So, ready for the classic lawyer's answer, Mr. The answer to that is it
It
depends.
depends.
It depends on the type of trust that you are setting up. And truth be told, there are multiple different dozens of different types of trusts to set up. But the two that we primarily work with and that fit most families' needs is something called a revocable living trust.
Mhm.
And the other type is called an irrevocable trust. And
Right.
it's used primarily for Medicaid protection. On the revocable side of the trust, okay, the revocable living trust, you are generally the person who is setting up the trust.
Mhm.
You are also the person who is controlling all of the assets inside of the trust.
Right.
And you are also generally the person who is benefiting from all of the assets inside of the trust. So
Mhm.
you don't lose any control. In fact, you maintain it.
Mhm.
You have full control of everything. You can put things in the little red wagon. You can take things out of the little red wagon, and you can do whatever you want.
That's right.
On the irrevocable trust side of things, it's a little bit different.
Mm-hmm.
You're the person who's creating that trust, but someone else is managing it. So
Right.
someone else is the person that you have to name as a trustee.
Mm-hmm.
It can be a family member, it can be a son, a daughter, a brother, a sister, a friend. It can be a CPA, it can be an attorney, it can be any different number of things. And that's the person who controls it for your benefit.
Mm-hmm.
Now, there are some restrictions, but it's kind of fact specific and it gets into each and every person's, asset dynamics.
Right.
So that's the best I can do to try to answer that
Mm-hmm.
question,
Yeah.
knowing that it will depend on whatever your specifics are.
Right.
And we can certainly take that offline if you'd like to give us a call and be a little bit more direct for your specifics.
Good point. And even in some irrevocable trusts, some control and security is maintained, and the irrevocable trusts are rather flexible. So the next question is different types of trusts and which appropriate audience. And I can just address that. The primarily there's trusts you set up during your lifetime, like that revocable living trust that's set up during your lifetime. Legally, we call it an inter vivos trust because again, set up during life. Then there's an opportunity to set up trusts after you pass away. Those are generally called testamentary trusts, okay, because they're usually a part of a will. Now, the lifetime trusts, as Tony was sharing, can be revocable or irrevocable. I think Tony and I would both clearly agree a revocable trust can benefit any person, any age, any financial situation. The irrevocable trust, as Tony also mentioned, is primarily geared toward, and I'll say two audiences. One is going to be the long-term care client planning for potential long-term care, long-term care costs in the future and perhaps Medicaid benefits, but also an estate tax situation. So estate taxes are, and they're out there, they're real. There'll be some changes coming up at the end of this, well, perhaps with the presidential election and then again in 26. But there are estate tax trusts which are also going to be irrevocable in nature. So, next question, Tony. How do trusts handle the distribution of assets from the sale of real property? So, just in general, so whether it's an investment account or a house, how and the grantor, creator, client, parent passes away, what happens?
Yeah, so if we're in that revocable living trust realm, again, you've got full control. So if you want to distribute assets out, you can distribute them out wherever you want them to go. If you want to retain them in the trust, you can retain them in the trust. Continue to invest and do whatever you like. When we talk about taxes, and that's going to get a little bit technical, the taxes are all attributable to whoever created the trust, whoever that grantor is. So again, you have full control of the money. You still have to pay all the taxes, but you have access to all of the money in that revocable living trust.
Right.
On the irrevocable side, when we get into that potential for Medicaid asset protection inside of a trust, who's handling the distribution or the sale of assets? Who's handling that? That's the trustee. Okay.
Mm-hmm.
The trustee is the person who is managing that type of a transaction.
Mm-hmm.
And then again, we're getting fact specific into, well, what are the allowable distributions? Who's allowed to receive money? It
Mm-hmm.
all depends on what the family dynamics are and what the actual assets are for each individual client. And I go back to the LegalZooms of the world and some of the online document service providers where I say that really is such a false sense of security because every single family's situation is so different.
Mm-hmm.
It requires time invested to uncover and discover the actual needs and sometimes the needs behind the needs, right?
Mm-hmm.
When you tell us we need this income, well, we need it for what and for what purpose? And, we have to structure our plans to really dig deep and uncover those things.
Sure. And what's going to benefit the client the most?
Right.
Agreed. Agreed. There's a question here about, so just trying to understand it and paraphrase it. The idea of the person has a power of attorney. It's an online form, and I know we've kind of said that they're a little indifferent to what the client's actual needs might be, but when it comes to powers of attorney, Tony, whether it's an online form or a simple what we call statutory form, Does that suffice? And if not, what then should be done?
So working backwards a little bit, does that suffice? Generally speaking, no. Again, we'd want to review any specific document before we made a judgment whether it was valid and enforceable or not.
Mm,
But generally speaking, those documents are just shells.
mm,
And what needs to be done in that case is you need to have them reviewed by an attorney who is accomplished and deals with and understands the nuance with different law changes when it comes to power of attorney.
mhm, mhm.
Not just actually making modifications, but then putting them to the test.
Yeah.
So when our clients have their documents and they walk into their bank to try to handle something with the power of attorney, does it work? What about if they have real estate in a different state?
Yeah.
What if they need to hire a caregiver? What if they need to open and correspond in US mail for tax versions or certain tax language is not included in that power of attorney? And now you cannot use the power of attorney for the benefit of your spouse or the person you have power of attorney over.
Yeah.
And so we have to get those documents reviewed. In our case, what we would do is just as we do comprehensive planning, we do
Mhm,
comprehensive reviews.
mhm,
Um, People schedule a consultation with us. We take a look at all their documents.
mhm,
Like when you bring your car in for a maintenance check, right?
mhm,
We do our own checklist. We go through things to make sure if there are any holes in your plan, we can identify those for you to say, is this a concern for you? We would recommend updating this. Um, and if you do, we can look at the different planning options for you to do that. But I would say
mhm.
definitely, if you have one of those online forms, it
Right.
would behoove you to get them reviewed by an attorney in your jurisdiction, New York. If you're in Connecticut, then Connecticut or whatever it is.
Yeah, yeah, for sure. The bottom line is the power of attorney is only as good as what's written in it. And whether it's an online form or even the New York State Bar Association form, they are insufficient for a lot of the concerns that we face as we age. The state puts out a standard form. That's good. It's a form, it's a template. There's a section for modifications. And the beauty of working with a firm like ours is we're going to modify that power of attorney. So no matter what happens down that road, whether we're dealing with tax concerns or we're dealing with retirement accounts, we're dealing with Medicaid benefits for long-term care, estate taxation, creating trusts, funding trusts, all of those language, all of that language and all those paragraphs, all of those modifications are inserted. We want our clients to have as much flexibility and control as possible. So with that said, we're going to wrap up. We're out of questions. For those viewers, as Tony said, we're here. If you'd like for us to review, if you have questions, tullyelderlaw.com is the website. We're happy to help, and we're here if you need us. All right. So again, thank you, Tony. For those that want to share this with their children, with their loved ones, it will be on the website probably within 24 hours, and you'll get a notification, and then you can always share it from the website. All right. Thank you, Tony, for joining us. It's been a real
Thanks, Brad.
pleasure, and
Thanks,
thank you
everyone.
for our attendees. Bye bye.